My name is Chris Morren, and I'm a retired physician. I represent Mystic Geriatrics Institute, Seniors Strong Communities. It's a organization, a local organization founded 10 years ago. And what we do is we try to educate the public, particularly seniors and their caregivers, on things that will improve the quality of their lives and their well-being. And I want to introduce our speaker tonight, attorney Jean Hendren. She is an elder care attorney, and she's practiced law in this area since 1998. Jean has an office at 12 Roosevelt Avenue in Mystic, the Packer Building, and she studied law at Washington University in St. Louis. She is a founding member of Mystic Geriatrics Institute, and now is an honorary member emeritus. So we at Mystic Geriatrics Institute very much appreciate Jean's work that she's put into getting Mystic Geriatrics Institute off the ground and helping us throughout the past 10 years. And I think, I hope, and I see some familiar faces here, people who have come to every talk, and I really appreciate your attendance. And without further ado, I'd like to introduce Jean.
Thank you, Chris. I am attorney Jean Hendren, and as Dr. Morren said, I have been practicing law, specifically estate planning, estate administration, and elder law in Mystic and the New London County since, I can't believe it, 1998. When people call my office, when new clients call my office and want to make an appointment, what we typically hear is that they want to come see me because they want to create a will or a trust. So what they're doing with those documents are they are planning for death. Those documents are wonderful, and they are actually your final act of giving, because you are giving everything that you have when you depart from this earth to people that you love. But this is a caregiver's seminar, and with caregiving, you are still very much alive. How many people in this room are actively caregiving? Okay, a fair amount of you. So the actual act of dying, according to Google, Dr. Google, is your last heartbeat. And that takes a mere second or less to happen. But the process of dying can be very protracted, and in that process, you are still very much alive. After having done what I do every day, I have come to realize that I am way more terrified in the actual process than the actual last beat of my heart. So that's how we're going to start today, is with the documents that are necessary, really, to have you still in control, even though you may not have full capacity or be able to have your actual voice heard. The incapacity documents versus the death documents are the documents that you need to manage and direct your process of dying. So now we'll get to the nitty-gritty. The first one is the power of attorney. And the power of attorney is a document that you create, and it's intended to allow someone in your period of incapacity to manage your financial affairs, your assets, and it also bleeds into management of your family relationships and social relationships. There are different forms of this document. The first one I have on my list is a springing power of attorney. And that document comes into play. It allows the person that you name as your agent in the document to take over management of your financial affairs when it's triggered by a certain event. That sounds very appealing. I am not a fan of a springing durable power of attorney because you have to prove that event has happened. And in the time that it takes to prove that that springing event or triggering event has happened, a lot can go wrong. So the preferable document to me is the durable power of attorney, which means once you've signed it, it's in full force and effect. And the state of Connecticut in 2018 did a power of attorney reformation where they allowed certain additional powers to be added to that power of attorney. So it has become a very, very powerful document. And if that's what you're looking for and you are concerned about perhaps Medicaid asset protection measures or very specific things, then you are going to want the long form version of that. The long form version has special powers, which allows very intimate, very specific things that your agent can do. So there's a short form which covers things like real estate transactions if your house needs to be sold. There's an enumeration of some powers. But if you really want a heavy-hitting, all-powerful document, I would suggest the long form. There's been a lot of controversy about these documents with respect to banking institutions. I don't know if anybody here has had trouble presenting a power of attorney to a bank, but they've become very wary of some of these documents. So the best advice is that once you have signed that document, you want to hightail it to your financial institutions and have them scan that document in. Powers of attorney will have an actual raised seal. I like to have them signed in blue ink because the technology for blue copies is not as good as it is for black copies. So when you present a document signed in blue ink with a raised seal, that's proof that it's a real document, and the banks will scan it into their system, take the original back for your safekeeping, and you should be good to go. The other thing that we have discovered is that a lot of financial institutions become wary of documents after they think they go stale after about 4 years. So I tell my clients to come in at that 4-year mark, even if it's the exact same document, they can just sign it with a new fresh date on it. We've had trouble with some banks thinking that a date older than 4 years is not good. The other unique thing about powers of attorney is that a superseding document will not revoke previous document. So if you have changed your mind about the agent that you want on that document, you are going to want to do a formal revocation of the old document before you present the new document. Otherwise, that they just think that you've added more people onto your list of agents for that document. And that's not the same is not true for something like a will, where you don't have to formally revoke the will. A superseding date takes care of that. There's a legal presumption. This is where I would normally, okay, good. I can't get out of my normal.
What does superseding date mean?
A superseding date is a after done document. So superseding would be if you did a document, if you signed a power of attorney and in a year ago, and then you signed a new one tomorrow, the new one supersedes the old one. And so if you were doing a will, if you did a will last year and then changed your mind, came in and did a will this year, that will, with the later date, cancels, with the superseding date, cancels out the old will. But that's not true for powers of attorney. All right, so moving along, we've taken care of the financial aspect of it. Now you have the physical you that you need to worry about. And that the document that covers your physical well-being is called the healthcare proxy. And what the healthcare proxy does, you name a healthcare representative, and it allows that person to obtain your medical records and to manage your day-to-day physical well-being. That could be choosing a facility if you need to be in a facility. That could be choosing to keep you at home, working with hiring caregivers, hiring new physicians. It stops short of allowing that person to have independent decision-making with respect to end-of-life issues. So it's more of a day-to-day management document. And although the medical community seems to be currently a lot more trusting than the financial professionals, it's my recommendation that you also update that document when you do your powers of attorney. A fresh date is a guarantee that the document's going to be accepted when you need it to be accepted. And then lastly, the third powerful document is the Advanced Healthcare Directives. It's more commonly known or referred to as the living will. In the living will, you are not naming a person. You are making a legally binding statement to the medical profession, your family, your friends, about what your terms of end of life are. When is enough enough? How far do you want to go? And that document, you're stating your own terms. And having signed it, that it gives guidelines to the medical community as to when they can stop trying to keep you alive. And it's often pull the plug. You know, that's the pull the plug document. When you check into a hospital, if you're about to have a procedure, you will be asked if you have a living will, and you will also be asked if you have a healthcare proxy. I have seen clients come into my office when they've signed the hospital form of the living will. It's about a half a page long, if that, and it is not enough. It's so much gray area, they're going to keep you alive with that document. So my advice is, when if you're doing estate planning or incapacity planning, have a living will that has a lot of meat and direction in it, because otherwise people aren't going to know what to do. And while we're talking about these documents, especially the living will, and the healthcare proxy, it's not enough to go into an attorney's office, sign the document, and then lock it up. Because in the healthcare proxy, you are naming a healthcare representative. That's the person that's going to advocate for you. And you need to have a very frank and open discussion with, at a minimum, that person about what you want. What is enough? I had, because that person is the one who's going to be responsible for bringing your healthcare proxy or your living will out and presenting it to the healthcare community if they don't already have it. And if that person doesn't know what you want, they're still shooting in the dark, and they then have to use their own judgment. That is not a comfortable thing for anybody to make. I have a current situation where that's the situation. And what I find is it paralyzes people. They're afraid to make the wrong choice, so no choice gets made. So make sure that you're not just signing the document and locking it up. You're giving a copy to whoever you've named as your person or people, and have them read it, allow them to ask questions so that they know exactly what they are charged for doing. And another thing that's very, very important that I see all the time is who you choose on these documents.
Can you repeat that?
Another very important thing is who you choose on those documents. Typically, when people come in to do estate planning with me, a lot of times they're not really aware that I give them a package of documents, not only the death documents, the trust or the will, but I also have them sign the power of attorney, the healthcare proxy, and the advance directives. And what I see happen more often than not is a parent or parents who come in, they have 3 children, and they have to choose who they're going to name on what documents. And it becomes more often than not a thing of fairness. Well, we named child A as executor on our will, so we should probably name child B to do one of these other things. Oh, and then there's child C. But you can often hear the undertone of that conversation where there's clearly a child or, a child who stands out as being the person most appropriate, maybe for everything, and a child who stands out to be the least appropriate. It's not a time to try to be fair. You need to really step up, choose the person who's going to stick to it, and make hard, advocate for you and for what you want. Things can go wrong, and I can give you, I use this all the time, personal story of mine. My dad, my mom died when I was young, and my dad remarried someone who he loved very much, but she definitely came from a different background and had a different set of beliefs. He was, number one, terrified of having dementia. Dementia runs in our family. He was terrified of being placed in a facility, so he created legal documents to cover and to tell people what he wanted in the event that A, he had dementia, how far he wanted to go to be kept alive. He didn't want antibiotics if he had an infection. And he also did not want to be placed in a facility if there were other available options, regardless of cost. Ultimately, he had a series of TIAs, little strokes, and had vascular dementia, and then ultimately had a very large stroke which he worsened his condition, and he required caregiving. And my stepmother, who I do love very, very much, decided that was not in her agenda to be a caregiver, and she really didn't want somebody in the home providing care for him. These are things I hear all the time from my other clients. So he had done documents. I made sure of that. He lived in California, so they were California documents done by a California attorney. I am not licensed in California. The documents were locked up. I was aware of the fact that he had them, but my stepmother did not want me to have copies of them. So ultimately, he was in a facility when he didn't want to be in a facility, and he developed a pneumonia and a UTI, urinary tract infection, which put him from the facility into a hospital. And again, these are things I see almost every day with a lot of my other clients, this chain of events. So I knew he wanted to be able to have the refusal of antibiotics because he didn't want to be living in the existence that he had. And for whatever reason, my stepmother chose to say there were no documents. And she kept him alive. I knew there were documents, and she said she was going to refuse to present them. So he was kept alive in the hospital, not in any recognizable form. He clearly wanted to die and be put in hospice and die peacefully and comfortably. He wasn't even comfortable at that point. So ultimately I had to take my stepmother to court. That's, the worst nightmare. Your father's dying and you're taking your stepmother to court. So ultimately he was placed in hospice. The documents were presented and he had a comfortable death, but he didn't need to go through what happened in the middle. And that is an example of why you have to choose carefully. We all knew how she felt about death and dying, but my dad just couldn't bring himself to feel like he had betrayed her, which I know that's how he would have felt if he hadn't put her in charge in the documents. But remember that story when you're choosing someone who you know thinks differently about that than you do.
I'm talking about power of attorneys. I understand that some banks have their own form for power of attorney. So if I have my own, like with my lawyer, and also have the bank, is there any conflict between them?
That's a great question. And yes, there are some banking institutions, and they tend to be more investment houses, as far as I can tell, who refuse to accept. By law, they should not refuse to do it, but they do to accept one that an attorney has created. But they do it anyway, and they refuse to do business with you or hold your accounts unless you sign their own form of power of attorney. That was a big issue for a long time, and we used to try to fight that all of the time and argue with them. You can report them to the banking commissioner of the state. But I've come to the conclusion after reviewing a number of those documents that they're pretty harmless. They're addressing very specific things that are unique to their own institution and their management. And I've kind of come to the conclusion that it's the path, if that's where you want to keep your business, it's sort of the path of least resistance, and sign it. So the next thing is the estate planning. And again, I'm going to talk about this from a caregiver, caregiving perspective. And I know Michelle Dempsey is going to be speaking on Title 19 next week. But she and I work sometimes together with clients, and a lot of these planning documents will bleed into Title 19. Is there anyone here who is dealing with someone who may be potential for Medicaid or Title 19? Okay. So the estate planning documents, we know there's the last will and testament, and that is pretty simple. You are doing in that document, you're naming on your death who your beneficiaries are to the assets you have at the time of your death, what percentages you want them to have from your assets, and then you name an executor who is responsible for taking the estate through the probate process. And I'm gonna just deviate a little now and talk about in the probate, what constitutes the probate process. Because you have a trust, or you have the last will and testament, which, and then you can create a trust, which basically does the same thing that a last will and testament does. It says on your death where your assets go. And some assets go through probate and some assets do not go through probate. So just because you have a will or a trust doesn't mean that everything is going to go through the probate court. In fact, anything that's been titled in the trust is a non-probate asset because it's not owned by you individually, it's owned by you, it's owned by your trust. So I'm going to jump to what probate assets are and what they aren't, so you have an idea of when you're doing your death document, what the implication of that time-wise is. Probate documents or probate assets are anything that you own at the time of your death in your name alone. If you're a single person, that's probably your house and your bank accounts. It's anything. For married couples, it's probably, if you own everything jointly, you're going to have very few probate assets. A non-probate asset is anything that is owned jointly, has a beneficiary designation, or has been titled in the name of a trust that you've created. So when I'm meeting with people, a lot of times their goal is to spend as little time in probate as possible. So if you have assets that have the ability to have a beneficiary designation, by all means utilize that beneficiary designation, keep it current, make sure that your beneficiaries are all alive. And on your death, that asset avoids being hung up in probate court. It passes directly to your named beneficiaries on the document. Likewise, anything that you own jointly. The fact that you own it jointly means there's a co-owner, and the law implies that unless stated otherwise, there's a survivorship function to that. So you, on your death, that asset that you own jointly passes to the surviving owner of that account. And again, it's not an asset that goes through the probate process. And then anything in your trust, of course, is actually owned by the trust. It's not owned at you. It's not owned individually by you. So those also stay out of probate. You want to think about when you are doing your death document, what's important to you. For some people, I have a case currently where there was a lot of concern about the beneficiaries, and it was ultimately decided after much discussion that they were better off in probate court. So he took away, or he named his estate as his beneficiary on all of his documents, so that it would end up in probate court, and there was judicial oversight to keep his beneficiaries in line, which in fact, he was a very smart man because his beneficiaries are a handful. And the probate court has been wonderful at refereeing and keeping everybody in line. It would have been a free-for-all if there had not been probate court supervision. So probate court is not all bad. You cannot always avoid it. It's not possible to completely avoid probate. One of the things but you can mostly avoid it if you've titled everything with beneficiaries, joint owners, or have them in trust. The one thing that you will have to do is prove, and you do it through the probate court, you prove to the state of Connecticut that your death does not rise to the level of incurring a tax on your assets. And that threshold is set by the state and federal government. So the federal government has its own threshold for a federally taxable estate, and each individual state sets their own taxation threshold. Connecticut has thankfully recently decided that it's going to do what the federal government does, and that number currently is $13.6 million. So you are allowed to die with $13.6 million to your name before incurring a tax. But they do make you prove that when you die, they do make you prove that you fall below that limit. And there's a tax form that every estate should fill out and submit through the probate court. It's a confidential document, and it's submitted to the state, where you are disclosing everything, even though you've avoided having to go through the basically 9 months to 12-month probate process. You're still reporting everything that you had at the time of your death to the state. And that also, and I don't mean to get too technical, but that document also is very beneficial if you have assets like a home or a stock portfolio where they have appreciated in your lifetime. I have a lot of clients who have been in their house for 40 or 50 years, and they will tell me that they bought their house for $35,000 40 years ago, and now it's worth $600,000. You wanna, and if you were to give that home away in your lifetime, if your basis on a home or any asset is what you purchased it for. So for clients who bought a home at $40,000 and they stayed in it, and when they come to me and tell me, oh, you know, I've got, it's now worth $600,000, but I want to give it to my daughter. Giving it away in your lifetime, just giving it away, you're giving her your basis in that real estate. So you're giving her a house where she has a basis that's $40,000. If you wait to give it to her until after you've died, you fill out the tax form, and that triggers what's called a step-up in basis. So that daughter now gets that home at your date of death value, the $600,000, and if she wants to sell it, for $600,000, there's no capital gain. If she had taken no 20% capital gain tax, if she had taken that home while you were alive, the capital gain tax would be based on the difference between $40,000 and $600,000. So, if you're doing estate planning, really talk with your attorney about the assets that you have and their value and how best to pass them on in the least costly way to your intended beneficiaries. And I'm jumping around on the outline because I can't take questions. But so the one way, and again, this is talking, why would you want to give your home away while you're alive? The basic reason is because you're trying to get that asset out from under you because you're afraid that you might end up with very expensive long-term care and end up on Medicaid, also known as Title 19, and have to maybe have a spend down, which could possibly include selling your house, or the spend down definitely includes getting rid of your assets that you've worked so hard to save in your lifetime, and your intention is to pass it on to your loved ones. So I have, people come in and say, well, I just want to get rid of it now, so I don't have to worry about it. She'll have it. But there are other ways you can go about that, which allow you to have the step up in basis and also maybe protect the house. Or whatever the asset is. And we do a lot with houses because oftentimes your house is a person's biggest asset. So there are different forms of deeds that you can do to protect the house. The sort of gold standard of that is to do a deed where you deed it, and you're deeding a future interest to whoever, your child, whoever, and you're retaining for yourself a life use. So the deed actually says, I give my real estate to so-and-so, but the grantor, that's you, herein does reserve for the rest of his natural life the unrestricted life use. So you're allowed to live in the home, control the home. It feels like nothing has happened at all. The tax bill comes in your name, you're responsible for everything, all expenses, maintenance while you're alive. And then on your death, the future of the home is locked in. It passes, again, you've turned it into a non-probate asset, so it's not getting hung up in probate court, and your person is getting the step up in basis. So it's like a beneficiary designation. And for the state considers the gift to have been made when you sign that deed, even though the property doesn't really transfer until your death. Okay, so I've covered a lot. Let's jump back then to the estate planning section. I've talked about just a simple will and what that does, and what a trust can do. And again, if you are concerned that there is going to be a long-term care, expensive long-term care situation, and you might have to make an application for Medicaid, most husbands and wives do what I call I love you wills. They say, they come in and they have mirror image wills. They do their estate planning together and they say, I give everything to my spouse if he or she survives me. If not, I give everything to, most likely, my children in equal shares. If long-term care is a concern between two spouses, that one spouse may, has been given a bad diagnosis, and there's the expectation that, or the fear that the assets aren't going to cover that, you want to break that pattern of wills. That's not a good pattern of wills, because what could happen, and what does happen when you have these I love you mirror image wills, if the healthy spouse ends up dying first, which does happen, they get worn out with caregiving, things happen, then you've done all this asset protection and the healthy spouse dies first. The unhealthy spouse, who's in fear of being having a massive spin down and running out of assets, then inherits everything as from the healthy spouse, and is sitting then with an individual lump of money and owned individually. That is all going to be subject to a Medicaid spend down. And for a single person on a Medicaid spend down, you have to spend your assets down to $1,600 before you're eligible for Medicaid. So there's not much of an opportunity to save anything. And the better thing to do, and it sometimes doesn't feel right in your heart, but it is honestly the better thing to do, is to break the I love you wills and have the healthy spouse do a new will that only leaves the statutory amount, required amount, to the unhealthy spouse. In Connecticut, you are not allowed to disinherit your spouse by law. You can if your spouse is okay with that, but the state of Connecticut is never okay with that if you are applying for Medicaid. So that the state forces you to take what's called the statutory share, or elect to take that. So we typically just build that into the will, but the statutory share is, the state of Connecticut requires you to leave to your spouse what a 1/3 life interest or life estate in the inheritance from a spouse. So what that boils down to is 1/3 of the healthy spouse's assets in the will go to a trust for the benefit of the unhealthy spouse. And the statutory share is 1/3 life estate. So 1/3 goes into a trust, and the life estate part of that is that they're only entitled to income from that 1/3 share. So for the rest of the unhealthy spouse's lifetime, they are entitled to to the interest earned on that 1/3 portion. 2/3 go safely, pass outside, and go to whoever the other beneficiaries are. So you've saved 2/3, and then upon the death of the unhealthy spouse, that original 1/3 amount is still intact because only interest has been paid out. That then can pass out to the other beneficiaries under the will. And you've gone from giving an unhealthy spouse your entire estate that gets spent down to $1,600 to successfully passing out your entire estate to other beneficiaries. And typically, it's children. People ask me, I often get called in, or people come see me when they call up, they say, I need a trust. I want to protect my assets. It's a myth that all trusts will protect your assets. They don't. The most common form of trust is what's called a revocable trust. And those do nothing for protecting your assets on death. They, while you're alive, because it's a revocable trust, which means you can revoke it, you can change it, you are the trustee most likely of it, you're in control of all of it, it's deemed to be yours and accessible. So if you were to have to go on to a Medicaid spend down mode, those assets are available for the spend down. Just because they're in a trust doesn't protect them. Some people do put their homes or other assets in irrevocable trusts. Those are separate legal entities that you create, and as soon as you create them, they are no longer yours. That's how they're different from revocable trusts, where you have control, they're still your assets, you can change things in and out, you can cancel the whole trust if you just decide you don't want it or you need the assets from it. An irrevocable trust, that's not the case. It's created, you cannot be trustee of that trust, which means you're not in control of that trust, and you have separated yourself from those assets. They do work for asset protection, and a lot of times people say, I'm going to live in my house forever, and let's just put it in an irrevocable trust. I like that. It's going to save that asset. And it will do that. But for me personally, I think there are better ways of protecting the house that give you a lot more flexibility. Well, and I'll just touch on real estate again, since we're just talking about the house. So I talked about the deed with the reservation of life use, where you're deeding the home and basically giving a future use. There are two other types of ownership. And for people who own real estate jointly, there can be jointly with rights to survivorship, which is like creating a beneficiary designation. You own that asset in an undivided way. It's a whole owned by both of you. So the survivor, on the death of one, that property, the real estate transfers directly to, as if it were a beneficiary designation, this survivor, and it keeps it out of probate court. Sometimes you will see that people own things as tenants in common. That is a joint ownership, but what you are owning, if it's two people as tenants in common, you are owning a very specific 50% share individually. I see this type of ownership a lot with inherited properties between siblings. Siblings may own a vacation home together that's been passed down to them, and they each own, if there are 3 siblings, they would each own an individual 1/3 share. If you own anything like that as tenants in common, your portion of that is a probate asset. It has to go through probate and be passed on to your beneficiaries. And that's just something to be aware of if your goal is to avoid probate. Okay. 10 after 7.